So we all know what to do when a family member passes on. Contact the family and friends, make arrangements for the funeral, transfer some money to pay bills, and don't forget to inform the banks. No, the last people the beneficiaries should notify are the financial institutions, the bank or broker of the deceased. What could happen if you don't inform the bank? Because a lot of people are worried about this and they get all freaked out. So what could happen? Well, you could get arrested by the estate police, possibly go to jail because this is illegal supposedly, and face fines or punishment of some sort. People have all sorts of weird ideas from the past. What will really happen if you don't let the banks know immediately of the death of your loved one? Nothing. There is no law that says the beneficiaries must notify as soon as possible the bank or any financial institution in the case of death of a family member. There is no timeline. You don't have a week, a month, a year. There's no timeline. So only their government pensions, corporate pensions, social security, or government support plans must be notified. Obviously, you have to let the banks know if you want to settle the estate. But if you're not ready, then take your time. There's no law that says estates must be settled by a certain date. Some estates take years and some are complicated. So what is the rush to inform the banks? An estate is not settled in a week or two. It takes a little bit more time. Take your time. There's no reason to let the banks know immediately. Most estates are settled by family members or the beneficiaries, and the family members or the beneficiaries end up being the liquidators. Many of them have full-time jobs, families, and other responsibilities. They will get help, possibly from a tax accountant or a real estate broker to sell a house or a property, whatever. It takes time. Every country is different. Check with your local laws about the information that I'm going to give you. This is for Canada. It probably applies to many other countries, but check it out. What you need? Well, in general, you must make an inventory of the assets and debts of the deceased, the original will search, certificate of death. You're going to have a list of all the beneficiaries, the appointment of the liquidators from the will, who is appointed, who's going to liquidate the estate, the letters of direction from the liquidators, and this is a very rough estimate of what is needed. We're not going to get into all these details. That's not the purpose of this video. But what happens when the beneficiaries notify the bank of the death of their family member? Well, the accounts are frozen except for deposits. All withdrawals are blocked, and the assets are transferred into an estate account. The assets are frozen until all the documents are submitted and the bank receives instructions from the liquidators with the letter of direction. So keep in mind the inconvenience of accounts frozen, investment accounts blocked or frozen, especially when you do not have your papers ready. This whole video is just about getting your papers ready and being prepared. That's all. Or you have problems of the liquidator or beneficiaries are not ready or can't agree or are in conflict and family fights. And this happens more often than people think. Settle all these things beforehand. Papers are not in order, frozen assets with incomplete paperwork. Until the paperwork is in order, the estate is in limbo. And it could take months or longer with frozen assets stuck in limbo. Just do your work beforehand. There's no rush to let the banks know. This is the advice that I got from my bankers, 2 big Canadian banks. Advise the bank when and only when ready. What does that mean, when ready? When the beneficiaries and the liquidators are all in agreement on how the estate is going to be separated or divided between the beneficiaries. In other words, you've done all your work, you know the laws, you know what's happening, you know what's going to happen. You are ready. That's when you let the banks know to start the process, and it is a smooth process because everything is in order. There's not a missing document or a problem, whatever. The deceased bank accounts, investment accounts, remain open and active until the bank is advised officially of the death. This is not an automatic process. If you don't let the banks know officially, then everything stays the way it is, and this can give you time, maybe a couple of months, to get ready. Not everybody's just ready to start selling the estate like the next day. And they suggest that financial and family obligations and business obligations should be settled before advising the bank. Everything is going to be switched into an estate account. That means that there's all sorts of payments, mortgage payments, maybe from a different bank. So you may have to advise your debitors or whatever that things have changed. And the estate and liquidation planning. I mean, this has to be planned, just like anything. How are you going to get rid of the estate? How's it going to be divided? And all the other things as well. Once you advise the bank, the legal process begins of settling the estate, liquidating assets, or transferring assets to the beneficiaries. Once you let the bank know. If you don't let the bank know, the process does not start. It is the beneficiaries and the liquidators that start the process by letting the bank know officially. A lot of people don't realize that. And if you're not prepared to start, don't advise the bank. That's the whole idea of this video. The tax department does not inform the banks in case of death of a taxpayer or share information like this between themselves. The government doesn't do anything with that. Keep in mind, everybody's going to keep it confidential. It's not learn as you go, because this could cost money and time. Questions are, well, how long can we take before we inform the bank? Well, they told me as long as it takes. Well, what if it takes 6 months before we are ready? Then it takes 6 months. Well, what if it takes a year or longer? Then it takes a year or longer. Keep in mind, you're like this plane. You're not going to leave or you're not going to take off until you get clearance from the tower. That means that everything is okay and ready and away we go. If not, you're better off to stay on the tarmac. Here's a situation that the bank told me about. The bank only found out about their client's death after a year, when the beneficiaries submitted the documents. What were the consequences? No consequences. The bank got the information. All the documents were ready. They were ready to go. They settled in about 3 to 4 weeks. Everything was in order. If not, things could have been in limbo for a while. So assets that are not with the bank or broker may be settled separately. But every estate is different and must go through the same process. Will they freeze the account automatically? Oh my God. No. And what's your definition of finds out about? As long as no beneficiary walks into the bank and blabs to the fact that their loved one passed on, that could be an official indication. As long as people keep it quiet, the bank may even know. So as long as all the mortgage and debt and monthly payments are made and all are up to date, no overdrafts, account is active. No red flags like mail being returned, the bank is fine. The account is active. What else do you want them to do? The account is in order, active, and remains open. And this could be for several months and possibly longer. That's all. What do you want the banks to do? If the bank has not been advised officially, they will do nothing. The accounts simply continue as before. The banks are not responsible if they have not been advised officially of the death. And it is in the responsibility of the beneficiaries or liquidators to advise the bank officially. And we'll get into what does that mean. The banks are not into freezing accounts automatically and pissing off the beneficiaries or clients. So my advice is keep quiet until ready. Do not blab to the branch that your spouse or family member has passed on. They know you're a beneficiary. That's officially letting the bank know. A lot of people think, the banks have all sorts of back office staff that are just ready to pounce. I mean, they're just going to pounce on you, and they just love freezing accounts and locking up accounts. No, they do not have a back office. It's sort of like checks, the obituaries with their list of clients to see if anybody is passed. They just don't do that. That's not what they're doing. That's not profitable. What is required to freeze a bank account or assets in case of death? The bank requires documentation or ID and verification. This may require a sit-down meeting with an advisor. But just somebody walking into the bank saying that I'm a beneficiary of Mr. Smith's estate, you'll have to show ID and documentation. Even if it's known and it's in the community, and I checked with the mayors of the city has passed away, you have their account. What do? The banks will do nothing. The bank will take no action until advised officially. They have not been advised by the family or the beneficiaries of the death. They're not going to do anything. These are safeguards that are in place. Not just anyone in the bank can freeze an account, a clerk, a teller. No, they can't. It's only certain people. There are safeguards for the bank and beneficiary protection. The banks want to avoid the scams in the past where people would just walk in with phony documents, freeze the account, and there was other scams going on. Errors, freezing accounts of people still alive because of errors. They don't want to go there. Pissing off beneficiaries by jumping the gun or letting anybody just freeze an account in the bank. No, there's new protections rules in place. And emails are not accepted. They will not accept an email saying, oh, by the way, so-and-so's passed on. No. You can see that it's not that easy to freeze an account. And they're going to verify this before they start freezing accounts. So things that could go in slow and block a settlement of an estate, problems with the will, no will, family squabbles, family issues, foreign property happens a lot, foreign beneficiaries, foreign taxes. So the beneficiaries are not ready to receive the inheritance. There's marital or insolvency issues. They're going through a divorce, or the beneficiary is in bankruptcy, and if they take in the assets, well, they'll just hand them over to the creditors, so they're not ready to receive it. They're not ready just yet. There's legal issues, tax issues. There's business deals that are in the middle or the process of being consummated. You have wills that are contested, unknown beneficiaries, unknown assets or debts, etc., etc. These are complicated issues, but you would be surprised how many estates are a little bit more complicated, especially for family members who, with no experience, were going to settle this. The other problem is no liquid cash or money to pay expenses, debts, or taxes. There's going to have to, you're going to have to raise the cash. And don't forget, you must file income taxes of the deceased to get the okay to start transferring assets or liquidating assets. It's called the release. So you just don't say, oh, well, let's start liquidating the assets and transferring them or dividing it up. No. You must file the taxes first, otherwise the beneficiaries could be liable for unpaid taxes, and that's a problem. There's cases of people living in houses for years without clear title. There was a person who was living in a house for 3 years, no clear title, because they paid all the taxes and insurance and upkeep. There was a problem with the estate settlement, or they were not ready to take over the house just yet. There was a mortgage on the house that they wanted to keep it going, whatever. But there's many cases of this happening. There's also the deceased account still active after almost a year. All the banking was done online, on automatic payments. The beneficiaries had the POA, or the power of attorney, with the bank and access codes to the account. So they kept mortgages or loans active, kept account active, and this, for whatever reason, and this can go on for years. And it has. Some people will only do that for several months until things are ready, but it could go on for a year for whatever reason until they're ready to settle the estate. There's all sorts of complications. It's best to do the estate planning while everyone's still alive, so everybody has a power of attorney. They're free at the banks. The account info and passwords, they're given to family members and spouses that are trusted. Surprises. There's property over here. You didn't know that there was a debt here. This should all be discussed beforehand. This can buy some time until things are settled out before you settle the estate. Deaths always happen at inconvenient times. Now, here's a comment from my advisor. After 10 years as a financial advisor in the bank and over 1,000 client meetings, I was the first who ever asked such questions or asked for information like this. A lot of people are not aware of what's going on, or they're still going by false information from the past. In conclusion, this is not a video on estate settlement, but on pre-settlement planning. Each country is different laws. Check it out and cover yourself. There's no rush to inform the banks. Take your time, do it right, avoid problems, and be prepared and have documents ready, family on board, and ready to proceed. Be in the know. Hopefully you enjoyed this video and you found it helpful. Please hit the like button and subscribe if you wish. And thank you very much, and I'll see you next time.